Welcome back to the Law Unscripted, where we talk about all the things about the law and the legal system that you never knew,
never understood,
and no one ever told you. I'm Virginia Tehrani.
And I'm Chelsey Rogers.
We are with Tehrani Law LLC because you never need a lawyer.
Till you do.
All right. We are back on defenses for crimes.
Give me another way to get out of this.
This is a fun series. It's almost been like a 3-part series.
No, it kind of is. I think it's interesting to think through, the ways aside from it wasn't me. What can we say?
Me. We're going back to Shaggy.
Yeah.
It's okay. So we started 2 weeks ago with murder.
Right.
Where we described what types of murder there are.
Yes.
So we described all of that. Go back to if you're interested in learning about murder, all things murder and homicide, go back to that episode. We'll put it in the comments or in the description. And then after that, last week, we started with defenses.
Yes. I mean, the most popular one, self-defense.
Most common and most popular. So we did self-defense last week, a little bit of alibi, and then defense of property. So your castle laws.
Yes.
I'm having fun with this. I think there are a lot of
these
interesting
are fun,
things.
and they're kind of goofy. When you take them out of the real cases, just some of this sort of rationale and how they came to be are just goofy things in the law.
Yeah.
And this one is crazy.
I love this one. So, yes.
Funny. I'm so sorry.
Thank you, Chelsey.
I don't know, overtook me.
I love it. It's great. It's great. So our punny friend over here has said exactly what our episode is on is insanity defense. The I'm crazy defense.
Yes.
It deserved its own little episode, and I think it's going to be shorter than our normal episodes, which maybe more people will watch, but we are going to focus on insanity, which is somewhat similar to intoxication as defense. So we're going to treat them in the same episode.
Because it's about the mental state.
Exactly.
At the time of the crime, right?
Exactly. So there are two things that you always have to prove in any crime is the mens rea.
Right.
Which is
guilty
mental
mind.
state. Yes. The guilty mind, the guilty intent.
Yes.
And then the action.
Yes.
So there's the mens rea, which is the mental state, and then there's the action. Did you actually do it? So in this defense of insanity, it's not about did you do it? It's about did you have the right state of mind? What was your intention in doing it? So like self-defense that we talked about last week, it's an affirmative defense where you have to say, I did it.
Yes.
I'm admitting and agreeing that I did this.
We're not going to have to do this dispute over the physical actions here, right?
Correct. That it happened. And then it's but
right, because that one is even sort of I have the mental state to harm this person, but it's like it was justified versus
for self-defense.
Right.
Correct. Yes. Is I knew what I was doing. I knew exactly what I was doing.
Yes.
But I did it on purpose because I was justified.
Right.
It was not a crime. It's like the God, now I'm going into more songs. I am not going to sing. Chicago. Right?
Yes.
The Chicago musical and the movie. I did not love the musical when I saw it in the theater. But then when I saw the movie with Catherine Zeta-Jones, Renee, what's her name? God, the other one who is absolutely amazing. Catherine Zeta-Jones.
No.
I
don't know.
I know her, and she was fabulous. They both were up for Oscars.
I feel like I can see it.
I see her very vividly. But anyway, so the Chicago, it was fabulous in the show because I could actually see and understand what was happening a lot more, put it into context. And all I can think was, no, you're going to sing. Exactly. He had it coming.
Right.
I didn't do it.
He only had himself to blame. I'm sorry, I'm a theater kid. I'm a nerd.
I love it. And that's what it is. And I keep hearing it was a murder, but not a crime. That line, it was a murder, but not a crime.
Yes.
That's what keeps playing in my head.
Self-defense. That's perfect. Yeah.
It is. It was a murder, but not a crime.
Yes.
I did it.
Yep. And I intended to do it.
But it wasn't a crime.
Right.
So that is the basics.
Yes.
And it's so funny that these are real world applications.
Hey, that is a real world application. I'm such a theater kid. Like, oh, it's so embarrassing. I thought I escaped it in my adult life. But, I mean, I'm sitting here on camera in front of a mic. Did I really escape it?
You didn't. It's all theater. It's all acting. But... okay, so it's like the self-defense, where you have to affirmatively say it. So in the episode last week where I said, procedurally in Virginia, you have to check boxes of what is your defense. And if it's just, I didn't do it, there's really no box to check. But if you do an affirmative defense, you have to check a box and alert the prosecution.
Right, that they're sort of on notice that you're either going to assert self-defense or put them on notice that you're going to claim an alibi that you were with a certain person or with...
I wasn't there.
Right. So that they can sort of bolster their case to refute that or... Yes.
Right.
And so this one is the same, right? That you have to put the state on notice.
You do. And I think this is fairly common in most states.
Yes.
I know it was in Virginia because I worked in Virginia, but I'm pretty sure that in Maryland it's the same in the other states is you need to put people on notice that this is your defense.
I feel like this is the one that is in every single movie and is very rarely, if ever, used truly. Like when you just think about the amount of defenses that can be asserted, because this is so difficult, I feel like, to actually prove.
It is very hard to prove. Right. And my understanding of the statistics is it's like 1%.
Yes.
Don't quote me on that, look it up, but it's such a small percentage of cases across the country
it's
that
disproportionately talked about, reported on, put in movies. It's insane.
Right. It is insane. It's the fun and exciting movie moment.
Right.
It's the great show for SVU, for the Law and Orders. It makes good theater.
Yes.
It makes great TV, even better movie, going. But in real life, it's very, very rare to even be pled, much less the percentage, the amount of pleadings are very low. Then the success rate is even lower than that.
Really not a very, and I do remember this, I don't know the exact statistic, but 2 years ago when I was in our 1L class, that it is not a very successful defense when it is asserted. The success rate is not great.
It's really not
great. So
great.
If you have anything else, you'd probably be better off asserting something else.
Yeah, or taking a plea, quite frankly. But yes, truthfully. It just, you have to affirmatively assert it. So you have to make a level of proof.
Right.
You have to prove. And the standard is different per state. Right. But you have to at least put some evidence on that is convincing to a jury that at the time of the offense, you lacked the capacity to understand and appreciate the criminality of what you were doing.
Okay. So that's a really interesting, and I've heard that phrasing a lot, but maybe people out there have not heard it.
Yeah.
That is an interesting way when we think, you're not just saying this person is insane.
Right.
You're saying they could not form the requisite mental state, right?
Correct. That they could not at that time.
By, mental defect or disease or whatever it is.
Through defect, disease, or whatever it is, just like you're saying, could not formulate the mental understanding and capacity to say this is right or wrong. Right. Which is what's required under the law, that you knew you did something wrong. So you did something wrong, but did you know?
Right.
So the whole case, the crux of the case is on the mental state of the defendant.
Which
at that time, not just the normal mental state. You can't just say, well, I had depression.
Well, here's her diary from 4 months ago.
At that time of the crime.
Anybody who's watching all of these, a couple weeks ago, we talked about during murder, and I said that that's hard, even when you talk about first-degree murder, that you're proving someone's mental state. It's the intent, it's the mental state, and unless they, you can form intent without doing anything physically. It's a lot of internal sort of thing. And it's like, how do you prove that? And it's the same thing with this is like, and the more we learn, I think, sort of in science about the brain and the way, I mean, there can be periods of clarity and periods of psychosis. And truly within psychosis, they are not able to, if someone is truly in a state of psychosis, they are not in a culpable mental state. They can't form a culpable mental state. But maybe the next day they are completely fine.
Yes. And that's why this defense was created, is there truly are some people who just can't.
Absolutely.
Whether it's an actual learning disability, some kind of actual physical or mental disability that the person has and doesn't grow out of, like it is there in a defect continuously, or whether it is a momentary defect that truly was
like mental illness,
a mental illness. But it can't just be any mental illness.
Right.
It has to have been one that affected their ability at that time to judge right from wrong.
I think that's the thing that's so hard. So, okay, two things. Sorry. What you're talking about, the sort of impairment.
Yes.
Overall lifetime. That's like the Making a Murderer series, like Brendan Dassey, that sort of the younger cousin there, like he seemed to have not, I mean, clearly he was tried and he was imprisoned, but there seemed to be a clear lack of understanding about anything that was happening.
Yeah.
And a lot of people have said that based on what you saw sort of in the interrogation, in the trial, sort of afterwards in these interviews, is that obviously I'm not a psychologist. I've never met this person. It seemed to be that even if he was there, even if he participated in whatever happened, didn't really have the ability to form what we're talking about, right?
Yeah, and so that goes to what you and I were talking about before this. And I'm sorry, I have a blanket. So for those of you who are like, why does she have a pink fuzzy blanket?
Because there's a puppy.
It's because they're puppies. We always have Willow and Charlie. So Charlie is hanging out with Chelsey over there, my little golden Cocker Spaniel. And to my left is Willow, my little merle-colored Cocker Spaniel. So again, they're dog traps. Yes. It's not that I need and depend on a fuzzy blanket like Linus and Snoopy in the Peanuts comics. It's because I try to, my little dog loves the pink blanket and will always snuggle. Usually she's more on me, but today she's beside me. So that's why I have a pink fuzzy blanket.
Yes.
Anyway, so there's the difference between competency and insanity.
And I think that is important and hard to understand because insanity, you're really talking about that moment of the crime being committed, which, again, so hard to prove because who's committing these crimes in front of everybody?
Right.
And even if they are, can you really tell me what's happening in their mind? Probably not. But then you have the competency issue, which the bar for that is kind of low.
It is low. It's extremely low. Now you have to be, so there's competency, incompetency can be claimed at any time.
Yes.
Anytime at all, where you say the defendant is not competent to stand trial. Because not that they don't understand the difference between right and wrong, but they don't understand what's happening.
Right.
That they cannot fully appreciate and understand the proceedings around them. They are then sent to some kind of
psychiatric facility.
Psychiatric facility where they're reviewed. Different states have different, qualifications. What letters do you have to have behind your name to review the person for competency? But it's usually low. Where do they understand what the judge does?
Right.
Do they understand what the defendant's attorney does? Do they know what the prosecuting attorney does? It's like very basic. It's the same for children.
I was just about to say, when you think about sort of the youngest children that have been tried in court, whatever their level of understanding is pretty much acceptable. Obviously, they were proved to be competent. So even if an adult has, what that 8-year-old or 9-year-old was tried with, then they're going to be like, well, If you can say the judge is the person who's in charge, and you can say the attorney is the one who helps me.
Yes.
That's basically the level of competency.
It is. If you have communication skills, if you can talk with your defense attorney, you're probably competent.
Yeah.
Because the bar is so low that they're going to say, well, you have the ability to participate in your defense. Okay.
Yes.
That's
Assist
kind of the
counsel.
standard.
Yep.
Mm-hmm. And if you have that ability, now the incompetency can be found a lot more than insanity.
Yes.
Because that applies to many more crimes where it's any defendant for any case.
Yes.
If you are not competent to stand trial, you're not competent in anything.
Right.
Doesn't mean you're insane. It just means you're not competent. A lot of very mentally ill people fall into this. A lot of homeless people fall into this. A lot of homeless also have a lot of the mental incapacities. But I've had, in my own career in reviewing cases, the defendants that I saw who were incompetent were most often those with drinking problems.
Or somebody off their meds.
Or someone off their medications, a schizophrenic who was off their medication. Someone with paranoia who was off their medication.
Who, when they're medicated, can function fine.
Exactly. So the idea is they can be restored to competency.
Yes.
And so they're treated. They're often taken out of jail.
Yeah.
Or if they're not in jail, if they're out on bond, that they're put into some kind of outpatient treatment program or possibly inpatient.
Right.
But they're put into a treatment program where they're attempted to be restored to competency. And if at any point a doctor, physician, nurse, whatever the letters are required, decides that they are now able to understand what a court proceeding is, what is happening to them, and are able to be communicative, they're back on their meds, their medications have leveled them out. That's usually what's happening, is they are put back on their meds are adjusted, and then they're usually found competent after that. There are some who never are. Right. There was, when I was in Newport News as a prosecutor in Virginia, there was one really sad case. And it wasn't even an insanity case. Okay. Because it didn't, at the time that I was there, it didn't even get to trial because he was incompetent. And it was a murder case. It was a murder case where it was a roommate situation. And I apologize. I'm feeling really uncomfortable, so I'm fidgeting a lot today. So I apologize.
I feel like normally I am, but I think my meds have kicked in. And I am
Chelsea's
I'm so focused. I'm like zoned in. I haven't moved.
It's hilarious. That's really, really funny. So, yeah. On that note,
ADHD is fun, guys.
Maybe you would be found not competent.
I mean, I would be. I don't know. I think
we need ADHD meds. That's all I'm saying.
It really helps me focus.
But
I don't know. But okay. So
anyway, so there was this really sad case.
Yes.
Very sad case in Newport News. I don't know what happened to it in the end because it was still in this same limbo state while I was there. There was a roommate situation, two men who were living together, not quite homeless, but on the verge of it where they were kind of
transient.
Exactly. Transient. And the one roommate beat the other to death with a milk crate.
Oh my God.
It was horrific. Absolutely horrific crime.
Yeah.
But all the time that I was there, it never went to trial because he was in a mental facility. He was in a hospital.
He just couldn't get to a point.
He couldn't. It wasn't even insanity. He was still not competent to go to trial. Whatever mental illness he was suffering from was so bad that he was just confined. Now, he wasn't on the street.
Right.
They did not release him.
Right.
Because his crime was so terrific in a bad way. They held him without bond, but in a hospital to attempt to be restored to competency.
Right.
And every few months.
So sad. He'll have a competency hearing.
We'd have another competency hearing where it would come back up, and whether he could or couldn't make it from the hospital, there would be another hearing where the doctor would show back up in the court and testify to the judge as to, this is how the guy's been doing. We believe he is or isn't competent. The judge would make a ruling. He would go back to the hospital or remain there.
That's so sad.
So I don't know whatever happened with that case. But that was one of the few where that I came across that was close to the insanity defense, but hit the competency first.
You could never. Okay, so in cases, say you pass competency, which is generally a low bar, obviously in this scenario.
Very, very low.
But generally pretty low. Most people are going to meet competency.
Yes.
But you have the right to assert whatever defense you want.
Absolutely.
So I think the big buzzword is temporarily insane. Temporary insanity. Right?
Yes.
I am perfectly competent. I am fine. I am healthy. I am capable. But at that time, I was insane.
Yes.
There's a lot there.
There is a lot there. It is absolutely a lot. So you check the little box that you're going to claim it, and you have to have experts.
Absolutely.
It's like a civil trial. Sweet pea. So it's like a civil trial. Do you want to come back up? Here, come on. See, I've got your blanket.
So sweet.
We're trying. She loves to be up here, but the other little dog, my other dog, Sky, is on the side.
They're trying to squeeze in together.
Come here. You got it?
Adorable.
Yeah, I don't know how much you can see of her, but now she has rearranged herself by my legs. So anyway.
Okay, so if I want to say whatever, I committed a crime. We'll say murder. I murdered somebody. I say, I'm competent. I'm clearly competent in our, pre-trial hearings.
Yeah.
But I say, hey, you, Virginia, as a prosecutor, I'm representing myself. Insane. Don't do this. I'm going to represent myself.
Yeah, please don't represent yourself, whatever it is.
No, never. Because
I would never even represent myself.
No, I mean, it's the whole thing of
can't.
like the attorney who represents himself as a fool for a client.
Yeah.
True.
It really
but
is.
in our little hypo, okay.
Yes.
I murdered somebody, but I'm also going to represent myself.
Okay.
So we get to our pretrial hearings.
You are insane. Just that alone is insanity.
Honestly, that should be like the judge is like, you sure?
Done.
That's what Ted Bundy did. I mean,
that's true.
Which proves the point, right?
Yeah,
like proves
it really
it in itself. I say, I'm completely competent. I'm fine. I'm good to go. But when I killed that person, I was insane. It was a fleeting moment of insanity. What do I need to assert? What do I need to prove? So experts, you can have somebody come and say, yes, they were insane at this time.
Correct.
And then you're going to have the state say they were absolutely not.
Correct. The state has the right to examine you too.
Right. Absolutely.
So by asserting the insanity defense, you have to allow the state to come and examine you too.
Right.
So you will have someone from the state who has reviewed your case, looked at your files, looked at your medical records, heard your story as to why you think you were insane, possibly has even looked at the defendant's expert and their reports and has said, okay, look, I see all this. Maybe they were suffering from anxiety, depression, schizophrenia, whatever it is, but that didn't make them insane. It made them ill.
Right.
But it didn't rise to the level
knew right from wrong.
of knowing right from wrong. And in that case, the jury would have to decide, okay,
who do they believe, right?
Who's the most believable? And I'll tell you, if the defendant is sane at the time of the trial, it is extremely hard to prove that there was a fleeting moment of insanity.
Okay, I have one for you. This is a Criminal Minds scenario, but I think it works.
Okay,
no, I think
give it to me.
Because I think, and I'm asking you, I think this might actually work for a fleeting moment of insanity. But the hypo is from Criminal Minds.
Of course.
The whole plot line is that there's this man, he was special ops, soldier, comes home. He lives a normal life. He has a wife, kids, everything. He gets into a car accident and it triggers very intense PTSD where he, obviously in this show, is like having full hallucinations.
Sure.
And so he sort of is pretending to like hide in the construction sites, like it's a war zone, and he kills somebody because he thought it was like a construction worker, like walking into the scene.
Okay.
He's having full hallucinations.
Yeah.
They get him back. they get him treatment. Would that work for a fleeting moment of insanity?
It's more likely.
I feel like that one is a pretty good,
That's
right?
a great example of one that might succeed.
Because I feel like that would be believable.
It is. That is much more believable than just a random person.
Yeah.
Where you have an explanation as to a severe PTSD, a flashback to a war experience.
And he had been receiving treatment for, and they say, sort of this accident, like...
Triggered.
Yeah.
Yeah. That makes a lot more sense.
Okay.
That is probably one that's more likely. There's another one that I've seen where a guy, and again, I'm telling you tragic stories.
Yeah.
Where it wasn't a murder.
Okay.
It was an arson case. And generally you can only assert insanity for serious felonies.
Yeah.
But it was an arson case where a warning on this one, you may want to pass by it depending. Okay. It's a little worse than some of my stories. God, I've seen so much.
You really have.
So it was a guy who tried to kill himself.
Oh, wow.
By fire. And literally poured gasoline on himself and around him and lit himself on fire in a house.
Oh, my God.
Burned the house to the ground, and he lived. Okay? And the prosecution charged him with arson. The plea was insanity. That at the time, he was so off because he was trying to die.
Yeah.
Right? That he didn't have the intent to burn the house down.
No.
That his only focus, his only intent at the time was to end his life, and he would do so in whatever way that he could without respect to the law. And that was one of the better uses of it that I've seen in real life, that you could look and be like, wow, if someone is that desperate in that time and he didn't actually make it. So I don't remember if that defense won because, again, I don't think I was there for the remainder of that. But it is one that was that was stronger.
Seems to make a little bit more sense
than others. The ones I've seen it in public in America the most often, and you're going to appreciate this because we actually talked about it a little bit ago on our other podcast, the Legal Weekly Wine, where it's mothers who kill their children.
Yes.
End up pleading insanity, where they will say there's postpartum depression.
Yes.
Or something that triggered, they were dealing with some kind of mental break at the time because what mother would kill their children? Yes. So clearly there would have to be some kind of mental shift, break, crack, whatever it is for a mother to kill their children.
So, and yes, this makes a lot of sense to me. Again, we talked about a more recent case, which is just heartbreaking. But I think what I learned through, I know it's so sad. I'm like being so emotional on our podcast lately.
No.
The world is just like a bad place recently. And I hate looking into it. But in this case, or in my research for that case, I guess what I meant to say was that postpartum depression is so common.
And it's real.
And it's so real.
Absolutely real.
And what I didn't know, I was pretty familiar with postpartum depression, but postpartum psychosis is actually still extremely common. Like, this is not 1 in a million. This is, you probably, if you know people who have had children, you probably know someone who's experienced postpartum psychosis. And what my understanding, obviously I'm not a doctor, but from the research, it's that because you've just had a child, there's a lot of fluctuating things in your body, and it can really mess with your brain. So in a lot of these cases where someone kills their child or children, it's usually, which also, this is so scary, reasons not to have children, number 8,000, you could experience postpartum psychosis up to 3 years after a birth. Like, have no symptoms, and then it randomly 3 years.
Yeah.
Terrifying.
Well, add the medications in.
Yes. Well, and I think that's what we're going to talk about next is the sort of intoxication style of this. And here's the one I want to throw at you. I think this is, like, to me, the sort of the most famous one. The person who takes Ambien and says, I killed whoever. I killed my wife, but I didn't mean to. I mean, I physically did it.
Right.
Wasn't there.
Right. And that's the question of which do you plead? Do you plead insanity or do you plead intoxication?
Right.
And so here's the deal with the intoxication. In most states, the rule is you cannot plead defense of intoxication.
If it's voluntary.
Except for murder in the first degree.
Oh, wow.
That is the general rule, is that it only applies for one time.
Yeah.
And it's not to excuse it.
No.
It's to reduce it.
Okay.
So the idea behind an intoxication defense is, I did it.
Yeah.
It wasn't self-defense.
Right.
It wasn't insanity, but it was a type of insanity.
Right.
It was, my thoughts were skewed
Yes.
by intoxication. So they're arguing that it's not premeditated
Right.
murder because their mindset couldn't premeditate.
Yes.
But because of a level of intoxication, it should be reduced to second-degree murder.
Okay.
Or voluntary manslaughter. So it's an imperfect defense in a way.
So, okay, I have a couple of questions. So first, to clarify, this is not I go get drunk and decide to kill somebody. That's because that's a voluntary intoxication,
Correct.
right?
It has to be involuntary, which is like, how do you involuntarily get drunk?
Well,
but yes, if you voluntarily go out and get smashed
Right.
and then go commit a crime, well, they still claim it's premeditated
Yes.
because you chose to do these actions.
Right. So this is something like you said, a medication reaction, like with the Ambien. Maybe
Yes.
someone slipped you something and you
Right.
had some reaction, whatever.
Right.
Those type of scenarios. But this is not, you could be found not guilty by reason of intoxication.
Not usually.
Okay.
I don't know of any states. There may be some out
there's-
there.
I mean,
but usually it is not a finding of not guilty. It is a
Interesting.
finding of a lesser charge.
Okay.
That your intent, the level of your intent, that it's not malice.
Right.
It's not malice of forethought because you're not having a forethought.
Right.
Right. It's, you did it.
Yeah.
But because of your level of intoxication from alcohol, drugs, or
Right.
otherwise. But it fits into the postpartum issue is this new case.
Yes.
Remind me the name.
Lindsay Clancy.
Lindsay Clancy. From our understanding, the attorney has come out and said that it's an issue of intoxication based on her medication.
Yes. So she was being treated for postpartum depression. And it seems that she tried a lot of medications and they were coming off of some, trying new ones. I think my understanding is at the day that she killed her children, she was on 5 or 6 medications. And I'm not talking about like ibuprofen. Like these are
serious medications.
I'm a big chicken. I aside from my ADHD meds, like I don't take medicine. And so this is crazy to see like the strength of the medications she was on and the amount. And obviously her trial hasn't happened yet, but from what her attorney has said, he seems to be floating the theory that a reaction of those medications perhaps improperly diagnosed or doled out because she was taking them according to the directions. I don't think there's like a dispute about that.
And there may have to be, in that case, you want blood draws, right? You want to have a blood draw from the hospital that says at the time of the murders, what were her levels? What were the drugs that were in her system? What was the level of the drugs in her system? That would have to be a part of this trial.
And I think that, obviously we'll know when they come out, but I think at this point he's saying she took them as prescribed and they were improperly prescribed, or this is a freak reaction in her body. Seems to be the defense here.
And it's a question in that state. The question is the intoxication defense the equivalent of the insanity defense in that state? Or is there a difference? Is it the general rule that the intoxication will reduce it from a first degree down to a second degree, where this medication is a type of intoxication? Or is it the medication was so crazy that she was insane? And that's going to be where
it wasn't the medication and there was some episode of psychosis, right? And that is where you put in the insanity. So you sort of see with both of these. And why we kind of put them together is that it's sort of the lacking of that mental state. And was it by, some hormonal fluctuation that your body did on its own, or was it a reaction to a medication? But that's when you have the experts who kind of
they have to
duel it out.
Exactly.
Because, I mean, even with the research I did, it seems difficult to really, and of course this is so early on with the caveat, but how do you determine that? If, the doctor says, I have all these other patients who are on it, nothing happened. Well, that doesn't mean that they didn't cause this in her, right?
And just like with the self-defense argument, it is very fact-specific.
Right.
It depends on that person.
Yeah.
On their issues, their medications, how it responds to their body.
Yeah.
It depends on the time frame.
Yeah. And I mean, I think in this one,
fact-specific.
The prosecution doesn't seem to be buying it, to be quite honest. They seem to say that she didn't want to have her children anymore. She planned this out and she killed them.
Yeah.
And they
Full
are
premeditation.
They are very clearly asserting none of this. They're like, the psychosis is important. The meds aren't important. She planned this and she did it. And they've already, even at her arraignment, have offered facts to support that. And I'm assuming, I mean, this is me wildly speculating as I do, that because there was such an immediate public outpouring of everything about this case, is that they wanted to be very upfront about why she was being charged with what she was being charged.
Right.
I really do think that was a lot of why they put a lot of their cards on the table at the arraignment.
Yeah.
So we'll see with that one. But it's interesting because, like you said, her attorney could raise either defense. This was a moment of insanity because of psychosis.
Right.
Or this was a involuntary intoxication because these medications produced a result that, messed with her head, essentially.
We need to go to the state rule and see what's going on.
I don't know what's going on in Massachusetts, but we can look.
I mean, that's the interesting part is it does depend in each state. And also in each state, it depends on if you are found guilty and then reduced or excused by reason of insanity. Because you have to first be found guilty of the act.
Yes.
And a lot of states will have, including Maryland, will have bifurcated trials.
Okay.
Where you will have first a trial of, are they guilty?
Right.
Did they do it? And the jury will be asked to decide, did they do it? And then if they decide first that they did it, then they will go into a secondary trial of, okay, now that you found that he did it, we're going to say that he is not guilty by reason of insanity.
Or you should take, is this sort of like a presentation like sentencing? You're talking about mitigating
It's
factors?
very similar to a sentencing hearing in Maryland and in Virginia. I don't think they're bifurcated. I didn't do one fully, and I haven't done one in Maryland either, but I seem to actually know the rule. But in Maryland, the rule is that it's technically a bifurcated trial. But either way, whether it's separated or combined, the defense has to prove it. Whether it's by a preponderance of the evidence, where I think for the insanity, it's higher than the self-defense, that it's a preponderance of the evidence in Maryland. But in either case, if you're found not guilty by reason of insanity, you don't go free. You do not go free.
Be like, sweet, thanks, out of here.
Right. And in some cases, it's worse.
Yeah.
And I have heard of defense attorneys talking with clients and saying, well, you certainly can plead that, but if you do and you're found not guilty by reason of insanity, this is what your life is going to look like for the next number of decades versus if you just plead guilty and don't play the insanity card. And maybe they were insane.
Yeah.
But there's usually a commitment to an institution.
Yeah.
And it's going to be a high security mental institution. This is not, a play area. No. And every so often they're reviewed. So in Virginia, I was part of NGRI hearings. Okay. It's not guilty by reason of insanity. NGRI hearings. Wow. And we would have every so often these people who were actually released from the facility. In Virginia, they don't go free either. No. So they go on a strict probation.
Yeah.
Where they are reviewed. They are put into an outpatient program.
Wow.
Where it's the worst probation ever. Their medications are monitored. They have a social worker who does home visits, who shows up and, are they taking their medication? Do they have housing?
Yeah.
Are they doing all of the things that they're supposed to do? Are they participating? Are they participating in an outpatient program? Like, what are they doing? Sorry about the mic here. Hold on.
No, I'm not sure what shifted. Oh.
Yeah, something shifted, but that's okay. We're going to figure it out.
Okay.
I'm just going to hold the mic for a sec. So what's happening with it is they get reviewed consistently. I'm so sorry about this.
Just having a moment?
Yeah, we are having a moment. Let's try that.
I think that worked.
That's better.
There we go.
Okay, and hopefully the light is. We'll see. Excitement anyway.
Yes.
But
so it's part of counseling your client at the beginning.
Yes. This is what's going to happen. Let's say you even get released. Right? And it was very rare that they would get released. And if they got released, it was like, well, why are you released?
Yeah.
Because you're doing significant outpatient programs. You have to go to the therapies they tell you.
Yeah.
You can't associate with certain people or go to certain places, especially if alcohol and drugs are involved. So
I'm so sorry. I got like a hiccup yawn situation. I was trying so hard to.
It's okay. My microphone fell over, so it works. But there were those reviews, and you would be first. There was the NGRI review to see if they should leave, and it's always the battle of the experts. What are the experts saying who are caring for them? If they are released, then there's continuous experts and social workers who follow them, and then sometimes they're put back in. So it is not a nice process.
No.
It is very difficult to get out of the system. Ronald Reagan's shooter, Hinckley.
Yeah.
He's one of the most famous cases of not guilty by reason of insanity for shooting President Reagan. Mm-hmm. And he was in a facility for decades.
Right.
Absolute decades. And then I think he was released near Williamsburg.
Really?
I think so. I'll have to check it out. But it was somewhere in the Virginia area where I was living in Newport News, because I remember there was a huge outcry in that community where he was supposed to be staying of, wow, really? He's staying in our community? Wow. But he has to go somewhere. Yeah. And I think his family lived there. But how many decades did he spend in a facility? So it's not something to take lightly. It's not something... We're laughing at it because of the idea behind it, but it truly is very serious. It is very hard to prove. And the question is, do you even want to? Yeah. So that's insanity and intoxication in a nutshell.
Yeah. Those are some wild ones.
They are. They really are wild ones. And again, I've only seen a few in my career.
I mean, from my obviously expert opinion as a 3L.
As a third-year law student.
Right. It would seem to me, from everything we know, statistically, that if you had another defense, I would raise that, right?
Yes. If there's any other option,
or, if your client is just being stubborn, I guess you have to do what the client wants to do, right? But aside from sort of those scenarios, it seems like there are basically always better options.
Better ways to go.
Yeah.
Yeah. So that's it. I mean, there's always other defenses. There are different ones out there.
Yes.
But I think we've gotten with this little 2 to 3 parter, we've hit the main issues with murder.
Yes.
The main defenses to murder.
Yes.
And to other
Yeah, I mean,
crimes.
I think they apply to sort of a lot of things.
Yeah, I mean, they're especially violent crimes. So any kind of...
we're all kind of talking about like felonies.
A lot of felonies, a lot of assaults and batteries, that sort of thing. So a lot of it applies there. The insanity defense truly is mostly high felonies.
Yeah, I mean, I don't think you're going to get like a speeding ticket and be like, I'm asserting.
The judge might laugh at you completely and then actually order a competency hearing because clearly you're not competent if you're claiming insanity for a traffic offense. So there's that. But next time,
I'm so sorry.
What was
my
that?
defense to trespassing is, I was intoxicated by my runner's high. Like
happened onto the property.
Just my brain was just not even there. So sorry.
Yeah, good luck with that. Truly, you might need a defense attorney.
That's how I feel like if I was a partner in a big law firm, that is how I would haze my new associates, would be to tell them.
That's so funny.
I'd be like, you need to go into a court and this is what you need to argue. Just for funsies, you know? This is why I'm not a partner in big law.
You possibly could be, but I think your talents lie elsewhere, my friend. I think they do. So if you want to hear more of Chelsey, her ADHD, and her extremely entertaining life and thoughts, join us again. Hit like, hit subscribe so that...
leave some comments, some questions.
Right. When you're scrolling through, you find it again. You can watch the next episode. Choose what you like. Yes. Do leave questions if you want. Leave some comments. Leave some suggestions for future episodes. We talk about the fun things that we get excited about, but
we're going to be here every Tuesday talking.
So much of the law that truly isn't understood, but is fascinating.
Really
I think so. So join us. Do like, subscribe, comment. Follow us on the podcast if you're listening to audio. Put us, rate a review. Rate us, that sort of thing. And join us again next week. I think we've already got that one planned out. We've got some good shows coming up. But thank you for joining us. I'm Virginia Tehrani.
And I'm Chelsey Rogers.
And we are part of Tehrani Law LLC, because you never need a lawyer
till you do.